Welcome, everyone. Welcome. Thank you so much for coming. Welcome to the Rule of Law Speaker Series hosted by the Neukom Center for the Rule of Law. We're pleased to welcome David Chiu, the San Francisco City Attorney, as our first speaker for this quarter. David leads an office of public law offices, bringing landmark cases to protect and expand the rights of San Franciscans, while holding high-quality legal counsel to about 100 city departments, boards, and commissions. The son of immigrant parents, Chiu grew up in Boston, Massachusetts. He received his undergraduate, master's in public policy, and law degrees from Harvard. He served as a civil rights attorney, criminal prosecutor, member of the Citizenship Board as an assembly member in the California State Legislature. Law, and we have asked him to talk about the importance of state and local governments in protecting the rule of law. So please join me in welcoming.
Good afternoon. Thank you, Professor, and really appreciate the invitation to come and spend some time with all of you. And I'm really also just appreciate that I know some of you might have come for the free food, but the fact that you all here thinking about the rule of law, we need hundreds of rooms like you in schools across our country. It's also great on this campus, as Professor said, I went to substandard school in Cambridge, Massachusetts, and certainly having gone to law school in a place that is far colder in the winter, far warmer in the summer, I am super bummed when I come on this campus at the incredible experience that you have. But let me start by saying I've been asked to speak about some of my perspectives at this moment regarding the rule of law, and specifically the interactions federal government and state and local governments. And let me say that this is a topic that many of us in government have not really had to think hard about until this very moment. I'm also going to just mention by way of introduction that when I was sitting in your seats as a law student, I literally did not know what the role of a city attorney was, or even a county counsel. It was not a career path I had thought about. When I was in school, now this is a couple decades ago, the aspiration for many of us in law school were to work in the federal government, because that was where things happened. That was where we go to have impact. And I'm going to just open my observation, how I ended up getting into this work. That has to do with something that happened 11 years ago. I was a freshman state representative in Sacramento, had just been elected to the California State Assembly. And I was asked by author what they told me would be a small minor bill to address what was happening in fake crisis pregnancy centers. So I'll tell you the picture. If you see the bus signs, they'll say, "Are you pregnant? Are you scared? Come here." And there are several hundred locations throughout California, thousands throughout our country, where you walk in, you'll be met by individuals wearing white lab coats who you will think are doctors and scientists, who will tell you that if you want to consider exercising your right to choose, you will get breast cancer, you will become infertile, or you will become suicidal. And reproductive rights organization called the Reproductive Fact Act that required every health clinic in the state to provide a piece of paper to every pregnant woman walking through the doors that said very simply, just two lines: in the state of California, you have the right to prenatal care, you have the right to family planning services, or you have the right to choose. That was it. We passed the law, and I didn't really think much of it, signed by the governor. Then the law was challenged by in 4 district courts in California. And we thought, okay, here we go. We won in each of those 4 courts, 4-0. I thought that's great. Case got appealed up to the 9th. Okay, what's going to happen here? And the decision came down, unanimous, 3-0 in our favor, that the Reproductive Fact Act was. Now, let me just remind you that there was a time period not long ago when we assumed that the case known as Roe versus Wade was not we had all assumed that Roe v. Wade would be on the books forever. We had all taken it for granted. That Ninth Circuit decision came down in October of 2016. A few weeks later, the unthinkable happened. Donald Trump was elected to his first term. And a few weeks after that, he announced that Neil Gorsuch would be his next appointee to the bench. And a few months after that, my little Reproductive Fact Act gets appealed up to the big house. NIFLA versus Becerra. And I realized, oh my God, this was the 4 chess moves that they've been thinking about the strategy of. And after that, sitting as the author of that state law, as the 9 justices were literally debating what was the legislative intent. It was all I could do to just sit on my hands, to not stand at those justices, because it was obvious where this was going. We got the decision shortly after that. It was the first decision of the new Trump majority, striking down California's Reproductive Fact Act, at that time with a vote of 4 to 5. That moment, I decided to go. One, as someone who had not been practicing law, I was a elected official, I was a legislator for almost 14 years of that. Or sorry, at that point, that was about 10 or 11. But I decided that I needed at some point to go back to practice. But that case also really highlighted the inherent tensions that we have when you have a federal government that is not aligned or even supportive of the idea that state and local governments ought to be able to do what they want. So let me start with also kind of a related observation to my very first point, which is we have had a really long tradition in the United States of the federal government cooperating with, working with state and local entities, what I refer to as cooperative federalism. In fact, many Americans, when they think about what government is, they don't make distinctions between federal government, state government, and local governments. We're all just sort of considered this one big monolith known as the government. But as we've seen, as our federal government under the control of Donald Trump has become more autocratic, state and local governments, we have had to lean into our constitutionally protected sovereignties. We've had to act to uphold the rule of law that we understand, but the rule of law that has been on the books for centuries. When you have a federal government that is violating the rule of law, the Constitution on a daily basis. So today I'm going to discuss 3 sort of general observations about what this administration is doing to the rule of law, in particular when it comes to how it impacts state and local government. The first is one that is, and that is this federal government has been involved in a frontal assault on the policies that are set by state and local governments. I'll explain what that means in a second. But the second observation I'll talk about is how we've also seen a much more subtle administration of the enforcement of rights that are established by federal and state laws in a whole variety of contexts. The third observation I'll make is just about how this federal government is coming after state and local governments through the elections process, the idea of challenging fair and free elections. And as I talk about these observations, I'll also talk about the role of my office and offices like mine in this discussion. So the first observation around this frontal assault by the federal government on state and local. So let me take us back to a few years before Trump was reelected. Steve Bannon was asked, not been able to get out of my head for a couple of years. He described the pace and the relentlessness of how he was going to come at us with the phrase muzzle velocity. So he literally said, we are going to come after them, just vague them, but really referring to all of us, particularly state and localities that disagree with them. We're going to come at them, and every day we're going to take multiple shots at civil society, at all the things that we don't like. And what he specifically said, and I quote, they will only be able to defend, and we'll get everything else we want. So to give you a sense of what that pace has felt like. So my predecessor, who ran the San Francisco City Attorney's Office during Trump 1.0, he filed 2 lawsuits in my office during the first year of the second Trump administration. We have been forced to file 14 times. So if you do the math, we are litigating at 6 times the pace, not because we want to bring lawsuits, but because we have to, because every single day they are coming at us with muzzle velocity. Let me give you a sense of the 14 lawsuits that we brought. At one level, I've kind of broken it up into 3 categories. First, we have been leading a lot of the national fights when it comes to immigration issues. We were the first city to sue Donald Trump the day after he was inaugurated, day after he signed an executive order to try to ban birthright citizenship, which all you also know is a precedent in your first year common law class. Citizen who was born in my city, and during an anti-immigrant era, had the audacity to travel back to China to visit his family. And when he came back, he was held on a steamboat for 5 months while the federal government worked really hard to try to kick him out of his country. You all know the punchline. It was actually Chinese immigrant families that put monies together to hire the best lawyers that he could. And the United States Supreme Court, at a time when you had a federal administration that was very anti-immigrant, uphold the very plain reading of the 14th Amendment that says if you're born here in the United States, you are a citizen. The second lawsuit that we filed was on behalf of San Francisco and the county of Santa Clara, where you're sitting right now, to protect sanctuary cities. Donald Trump has real success about this is a fight during the Trump 1.0 era. We prevailed. But he doubled down again in the early part of his administration, and he threatened cities like San Francisco, counties like Santa Clara, to remove all of our federal funding, which for my city, by the way, is almost $4 billion. If we refuse to deputize our police officers as ICE agents, or in other words, he has wanted to commandeer all of our local law enforcement to be his extensions of ICE. Second category of lawsuits we've brought have been around federal funding. And let me explain, this is an area that all of us were litigating this know very well, but the public knows less well. You know that Donald Trump is coming after immigrants and the LGBT community, the idea of DEI, climate change, et cetera. But what you don't know is part of how to execute on his strategy is he sends letters out to every city, county, state in the country that says, if you would like to receive federal funding in this area, you have to sign a document that says that you will implement anti-immigrant, anti-LGBT, anti-DEI, anti-climate change, anti-reproductive rights provisions. You've got to sign on the document, which puts all of us in the position of making a horrific set of choices. Do we get the money? Do we give in? Or do we forego the money, which in the case of Sanctuary City would be $3.7 billion to continue our way? Or the third option is, do we litigate? 9 of the 14 cases my office has had to bring has been around federal funding. I will tell you, we were at the 9th Circuit this morning on a case that involved those kind of illegal conditions on funding for homelessness, housing, for us, funding to SFO, where you guys fly out if you want to go to other parts of the country, to the largest public transit system in the Bay, which is San Francisco's Muni system, as well as for health and human services. So over $2 billion at stake in the 9th Circuit courtroom today. On a different front, I'll just point out an incredible irony here. Donald Trump likes to refer to cities like San Francisco and other more liberal cities as cesspools of crime. At the same time he's doing that, he is trying to withhold public safety funding with all these illegal conditions. He's saying, literally, if you want money for cops, if you want money to prepare for the Super Bowl or the World Cup because the Bay Area happens to be a target for terrorism, you have to remove these conditions. So we have had to litigate these issues in the courts. Let me tell you about the third category of cases that we are litigating, and that has to do with public goods. Which is not exactly something Donald Trump believes in, but some of the cases we have brought have been on behalf of education. We brought the first lawsuit challenge the bastardization of AmeriCorps rules, trying to cut off funding to our schools around AmeriCorps. For those of you familiar with that. Here's a second topic that my guess is hopefully many of you are familiar with. Donald Trump has tried to change the rules when it comes to public service loan forgiveness programs. So in San Francisco, for example, we have 2,100 public servants who are having their loans forgiven because when they went to expensive schools, there was a commitment that if they worked in the public sector for 10 years, their loans would be fully forgiven. Donald Trump is trying to change that midstream. Another public good that we are pursuing is air we breathe, water we drink, climate change. Trump has come after all sorts of climate programs, including programs addressing environmental justice issues, the tax credits that came out of the Inflation Reduction Act, which are trying to jumpstart a clean energy set of industries throughout our country, and so on. Another set of public goods, healthcare. You all are very familiar with, or likely familiar with, what's going on with the big ugly bill, but you may not know all of the different ways in which Trump is coming after healthcare. I'll give one example of a case that we litigated. In the first couple of weeks of the second Trump administration, there was an executive order that came down that said, if there's health data around people who are different, particularly the LGBTQ community, say different folks, we shall eliminate all collection of healthcare data. So he moved to literally strip 80,000 websites and data sets from the Department of Health and Human Services, the Drug Administration, Center for Disease Control, et cetera. And it was my city working with a number of doctors that sued to successfully intact. One last lawsuit I'll mention as a public good, literally government itself. We had to bring a lawsuit along with Santa Clara to challenge the complete dismantling of the federal government. The idea that Donald Trump has that he can simply, with a wave of the magic wand, eliminate 40, 50, 60% of entire departments from existence. So we're litigating these cases. Now, a few things I will say about our litigation. We have a lot of the same claims in all of these lawsuits. So we typically are bringing 10th Amendment claims, right? This idea that the federal government is not resources. We're bringing claims, the idea that only Congress can change the law that allow him to do what he wants to do. They're litigating with the spending clause, the idea that the executive branch can't impose arbitrary or ambiguous federal conditions that have nothing to do with programs that we are entitled to under various. And we're litigating under the administrative procedures. It's also simply an acronym, but has turned out to be one of the most important federal laws that we have, which simply say to the administration, you have rules that you have to follow before you promulgate regulations to do away with what you want to do. Let me just end kind of this discussion of this first law by saying, when we started this litigation, there were very few cities that joined in this litigation because cities are afraid. Cities, the phrase I kept hearing was the eye of Sauron. Cities literally would say to me, we love the fact that you're litigating sanctuary city. We love the fact that you're litigating federal funding. But if we add ourselves to that, they'll take our funding away. So Chiu, go for it. Good luck. Go at God. That changed in the second half of last year. Why? And I'll give some data on that. So our sanctuary lawsuit that we brought with Santa Clara County, two of us, and despite the fact that there are hundreds of sanctuary jurisdictions, there were only 3 other brave cities that joined us. So you had a total of 5 local jurisdictions that fought for the first 6 months of last year. Today, at this moment, we have 6 jurisdictions that are part of that lawsuit. I mentioned today the case that is in front of the Ninth Circuit on issues of housing and transportation and health. We started ourselves, Santa Clara, and 6 other jurisdictions, so 8 local jurisdictions altogether. Today, we have 62. The reason things have changed over the past year is really twofold. One, and here's the really good news, is we are winning. We are winning most of these cases in the lower courts. I always have to preface it with that. Of the 12 lower court decisions we have received in the first 14 that we have sued, we have prevailed in 11 out of 2, which is remarkable, a testament to the fact that this judiciary is still independent. There is another reason, though, why local jurisdictions have realized it is in their benefit to join us, And that has to do with a Supreme Court decision that came down in the middle part of last year. Some of you are nodding your head. That put limitations on the application of preliminary injunctions. It used to be during Trump 1.0 that if my notice got a PI just for San Francisco on sanctuary, that would apply to everybody else. And so everyone else literally could actually free ride if we chose to invest our resources and we won the fight. After the Supreme Court Costa decision, that was no longer the case. And so all of a sudden, all these sanctuary jurisdictions realized, oh, wait, we can't wait for San Francisco to win. If we're not part of that lawsuit, we won't benefit from the victory. So that has to be pretty dramatic. Let me now talk about what I refer to as a much more subtle erosion by the federal administration when it comes to the protections of all of us in our states and our localities. And that has to do with the administration's abdication of enforcing a whole variety of protections that have been put in place for decades. So I'm talking about worker protections, consumer protections, environmental protections, civil rights protections. Historically, the federal government has led in this space. They're the ones who are active for holding bad actors, particularly bad corporate actors, accountable. And agencies, I'll just listen because I know this is a smart crowd. We're talking about CFPB, the FTC, Department of Labor, EPA, Department of Justice, all of its agencies. A lot of how they view their work was we are going to hold bad actors accountable. The Trump administration has, I would say, not just slowed down these efforts, but shut down these efforts. Let me give you some numbers. The organization Public Citizen recently analyzed that the administration has canceled 145 enforcement actions against 153 corporations facing federal investigations, enforcement lawsuits, or other measures for lawbreaking. And on top of that, there have been 14 corporations who had enforcement actions frozen. So we're talking almost 160 canceled or halted enforcements representing some of the largest issues. So let me just talk close about 40% of these actions canceled or frozen were against corporations for consumer protection. So just to give you a few examples, Trump's CFPB dismissed cases against Walmart and Branch Messenger. Those were two companies that were sued for opening up deposit accounts for more than 1 million delivery drivers illegally. They had harvested over $10 million of junk fees through Walmart's driver program. Another company, Rocket Homes, some of you may be familiar with that in the real estate space. CFPB under Biden had sued to stop an illegal kickback scheme that was steering borrowers to another company, Reliant Holdings. The CFPB had sued this company for legally baiting, gouging, trapping families in high-fee credit cards, where consumers were charged up to $300 a year in fees, and the credit card could only be used to buy overpriced items from a company that was affiliated with Reliant Holdings. I don't know how any of you feel about that, but you multiply that by the dozens of entities we're talking about. Now, one other thing I want to point out, as these decisions are being made to drop enforcement, dismiss enforcement, they might have the appearance of having been motivated by donations or ties to Donald Trump. So for example, Bank of America donated $500,000 to Trump's 2024 inaugural fund. And lo and behold, under Trump, the CFPB has dismissed a pending case against BofA related to alleged misconduct having to do with Zelle network banks for not doing enough to reimburse customers who were defrauded by scammers that were using that network. Toyota. A few years ago, CFPB had entered into a consent decree with the automobile manufacturer to address the fact that the company was literally directing customers who were trying to cancel certain things, sending them to a dead-end hotline. Literally, you would call the hotline and they would be sent in a circle. So there was a consent decree with Toyota over this. Toyota was supposed to do all sorts of things for consumers, and then they donated $1 million to Trump's inaugural fund. CFPB terminated the consent, and which literally meant that tens of millions of dollars that the Biden administration had gotten Toyota to agree to pay to consumers would not have to be paid. Just to give you a sense of other areas of enforcement retreat, there have been 22 matters in the cryptocurrency enforcement arena that have been pulled back on, 18 cases in the worker protection space, 17 cases in the antitrust and competition-related enforcement, 15 examples when it comes to foreign corruption and bribery. So that's the bad news. Those of you who had come to Stanford Law School thinking you were going to do this work with the federal government, I'm sorry to say, that's not a but let me tell you this. And in offices like mine, we are stepping. I, until recently, chaired an association of the largest city attorneys and county councils in California. We are leaning in. And I'm going to give you some examples of the type of cases that we bring, just to whet your appetite of what is possible. Because if the federal government is stepping in, we have to obviously step into the breach. So a couple of cases that my office have been involved in on the affirmative side when it comes to consumers. We sued the opioid industry, like many cities and counties around the country. We were able to win a $350 million settlement for San Francisco, which, by the way, was a record, involved a record per capita settlement of a single company paying to a city, at a time when 75% of folks on the streets of San Francisco who are addicted to drugs start their addiction because of something that they were prescribed earlier in their life. Big tobacco. Just in the last couple of years, my office has won millions of dollars enforcing some of our laws that prohibit companies that are legally selling flavored tobacco products or vaping products or pouches to San Francisco residents, particularly kids. Worker protection. A couple of years ago, I started a first of its kind for a local public office like mine. We have brought in, as of this week, $28 million with a handful of attorneys, particularly against companies that are misclassifying gig economy workers as independent contractors. And at this moment, we are litigating one of the most significant cases when it comes to climate change. Some of the biggest fossil fuel companies in the world, impact in sea level rise, and what it's forcing when it comes to billions of dollars of infrastructure that San Francisco has to pay. Let me give a couple of examples of cases that we've been litigating just this past year that are first of its kind in the country. So my office brought a first, actually in the world, case against 16 of the largest AI generating deepfake pornography companies. These are companies where you go to their websites and anyone can upload a photo. 99.9% of them are photos of women and girls, and turn it within 30 seconds into non-consensual pornography, which then floats in the internet. We sued the companies responsible for 200 million visitors in the first half of 2024. As of this moment, we have shut down 11 of them. Despite what the Trump administration has said on this topic, they have not yet acted. On a different subject, just Friday, I brought a lawsuit along with our Attorney General against a group of affiliated websites and individuals that are disseminating codes on their website that allow anyone to download those codes and use a 3D printer to create ghost guns or machine guns. I don't know how many of you are aware that this could be done, but it can be done. And it can be done by criminals, folks who are barred from owning firearms, or by your 15-year-old neighbor. A third topic I'll just mention to cases of interest to anybody. There has been a lot of discussion in recent years about the plight of so-called ultra-processed foods. And we brought the first lawsuit in the country to sue of the largest ultra-processed food manufacturers that are responsible on constituents in California and around the globe. So I mentioned these because, again, with the lack of federal enforcement, it requires our community in different states and different localities to step into. Let me talk about the third topic that I'm highly concerned about when it comes to what this administration is doing versus state and localities, and that has to do with how the rule of law used by this administration is impact elections. And let me just talk about something that had been under the radar really until the last couple of years. So the Trump administration sent letters to almost every state in the country and to many localities, including San Francisco, that said, you shall turn over all of your unredacted voter rolls. This includes information around social security numbers. This includes information around driver's licenses. They've asked this of everybody. A number of red states complied. But as you can imagine, a lot of states, red and blue, refuse to turn this information over. This issue is being litigated as we speak. In the early cases, we've been winning on this, but I mentioned that for the following context. So in the last month or so, the Department of Justice has been employing new tactics in this space. So in the same day that Alex Preddy is murdered in Minneapolis, Attorney General Bondi sent to Minnesota Governor Tim Walz a letter saying, you shall turn over all of your voter rolls. And that's one of the, quote, solutions to how you end our federal invasion, as if voter rolls has anything to do with ICE enforcement or military occupation. That same week, the FBI went into Fulton County, Georgia, to seize 200 records, ballots, voting records, as part of their effort to deny the 2020 electoral results. And up for a vote this week in the House of Representatives is the so-called Save America Act, which would put many more onerous requirements, particularly requiring proof of citizenship for folks who vote. And you may have heard last week, Donald Trump said that he believes that his federal government ought to get involved in elections. And within a short period of time, the same Steve Bannon who talked about muzzle velocity said, and I think we should have ICE and military troops guarding policing polling stations. So obviously, these are tactics that could result in many, many horrific outcomes. But I'll tell you what some of the good news is. One, we have this thing called the Constitution. And the Constitution says that it is state officials, and by virtue of that, it is local elected officials who have the responsibility for carrying out how elections are held. And I can assure you that in California, we are in good hands. I am confident that in jurisdictions around our state, as well as the administration run by California Secretary of State, we are in good hands when it comes to what's going to happen in 2026 in the election and what will happen in 2028 and beyond. But I am highly concerned about what may or may not happen in other states of the country. So let's recap. A frontal assault on state and local governments when it comes to our policies, the abdication of federal enforcement, undermining of free and fair elections. Do I have any good news? We start with a bit more bad news. Slightly stressed out that I'm going to suggest, because I know how much free time all of you students have, that you consider reading. It happens to have been written by some professors from my alma mater. I apologize for that. But the book is called How Democracy Dies. And the thesis of the book, and it's unbelievably compelling, is that as they looked at the history of the world over the last century, at autocracies that were originally democracy, you would think that that process happens typically quickly through violent coups at the end of a barrel of military takeovers and so on. Because in most, or many of these, that transition to autocracies occurred when head of a state of a country who is democratically elected decides over a period of years, months, weeks, or days to undermine democratic institutions. So literally the playbook that we are seeing today. I often think about how I'm not sure if we are living in 1933 Germany or 1939 Germany, but I think we are somewhere in that decade. I think a lot about the poem, and I'll just share, during that time period that said, first they came for the socialists, and I didn't speak up because I wasn't a socialist, and then they came for trade unionists, speak up because I wasn't trade unionists, and then they came for me, and there was no one left to speak for me. I think about the of that poem, it goes something like this. First, they came after birthright citizens and undocumented families. And they came for trans kids and our LGBT friends. Offers, came for universities, media, and they came for so on and so on and so on, all within the first year of this second administration. So what are we to do? I've had many conversations with friends of mine who are attorney generals, who are also kind of on the forefront of this fight. And we often talk about the 3 C's. The C's of courts, crowds, and courage. So courts, as I alluded to, at this moment, with two branches of government completely captive by the autocracy. We do have a judiciary that is still independent. And I might emphasize the independence is not just folks appointed by Democrats, but folks appointed by Republicans, including Trump appointees. And so, as many lawsuits as I filed, there are so many more lawsuits that we could be filing. And this is why I look out onto all of you, and I hope you guys are either helping out in some way or you graduate as quickly as possible to get involved in the fight. Secondly, I want to say, it has been dispiriting for a good chunk of this year at how we haven't been able to actually see people mobilize. And I'm not talking about physical crowds, although that is incredibly important. We need to see crowds out on the streets, taking the streets back to our country, but organizing people in different sectors. I know that not all of you are going to go into public sector law or litigate these types of cases. You may go into technology, you may go into real estate, you may go into venture capital, but we need crowds in every sector of society organizing, whether you're in the venture capital community or starting the next AI company or getting involved in land use matters, real estate matters, et cetera, et cetera. And so we need to organize, and we need you to think about what role are you going to have, whatever part of civil society you live in. The last thing I'm going to say is courage. Sort of goes without saying that for lawyers to do what they do, for crowds to organize, for any of us during this dark time of the rule of law, we need courage. Dr. King often talked about how our measure as human beings is not where we sit in times of comfort or convenience, but where do we stand in moments of challenge and controversy. And so, as Harvey Milk would say, as a representative of San Francisco, I have to quote him, I'm really here to recruit you. I'm here to say, we need you to get involved in courts. We need you to be involved when it comes to organizing and building those crowds. And we need you to have courage because we don't have enough of us on our side. But if we all band together, if you have the courage to stand up, if you have the courage to think big ideas, if you have the courage to think the rule of law needs to stand years and years to come, our Constitution needs to stand for years and years to come, I want to ask you to join us in our fight.
Questions, just come down to the mic.
Or you could yell it out and I'll just repeat the question.
So I'm curious if you could talk a little bit more about the interaction that you have with our own Attorney General in California and his office, because they've also been quite active and engage and strategize also with jurisdictions you met. Ins and outs of that.
Yeah. So when I was talking about crowds and organizing, I never expected that this past year for me would be a major exercise in organizing. I'll explain that in a few minutes. So first, to answer your question, Rob Bonta was one of my closest friends in the state legislature. And so it was just totally fortuitous that he became Attorney General, I became City Attorney. We had programs. So calls when a horrific thing happens, which is every day, we reach out and say, are you and your colleagues in the AG network going to take it, or should we in our localities do it? As you can imagine, depending on the issue, different parties have different standing and different cases that we can make and different narratives, frankly, around lawsuits. So in some instances, it makes a lot of sense for the AGs to sue. Others, it makes sense for local governments to sue, particularly if it involves federal funding directly to us where states don't have jurisdiction standing. In other instances, it's individuals or organizations that can bring lawsuits. And so we have many of those conversations. There's a lot of divide and conquer work that's happening. I'll mention that Democratic attorney generals worked very well and programmed together. And in the year before Trump was reelected, started thinking about Project 2025 and what they were going to do. They have been truly the gold standard in how to organize, and I'll explain it in the following way. They get on regular conference calls a number of times a week, and they have the discussion I just mentioned, which is what just happened, who is going to take an issue, who's going to research and figure out if we can sue. And maybe today it's New Jersey, next day it's California. And then, so they divide and conquer work, but then when someone is ready to sue, they circulate the petition, and 18, 26 states will sue at the same time. So that there is that. So when you go to the courts and explain this is something that impacts all of us. We didn't have that network when Trump 2.0 started. As city attorney, I thought we were all going to be joining in, but there were literally only a handful of cities and counties around the country that were engaged in this. Santa Clara being one of them. I'll single out Chicago County, up in the state of Washington. What we have done though this past year is we have built up that infrastructure in a lot of different ways. I mentioned that I am part of a network of the largest city attorney and county councils in California. So we program on a very regular basis in California on how to respond to some of this. But we are also doing that now regularly with 100 cities and counties around the country. Maybe introduce yourself.
Hi, I'm Martin, recently graduated from here, but I just wanted to ask, and you partially answered this with your last question, but given the constraints of staffing, the citywide budget crisis, and also a less friendly Ninth Circuit that one would like, how do you decide which cases to take necessarily?
That is a great question. So my office doesn't have the resources to litigate every single case that we. I have a relatively large city attorney's office, and it's got about 200 lawyers, a number of amazing graduates from your institution. We have to be, so we have a series of criteria, but as you can imagine, we're weighing how much does this impact our funding, how much does this impact our policies, are there any ways for us to get around litigation? Are there other lawsuits that are addressing these issues? And if the answer to those questions go a certain way, we litigate. My office has incredibly dedicated lawyers who this past year have been working around the clock because by and large, we didn't get additional resources given budget crises that the city are facing. We received a few extra dollars from the state legislature to be able to fund some of this work, but it's an ongoing struggle for us to be able to do this work. As Lucy knows, we have a relationship with some school clinics that have literally donated tens of thousands of pro bono student hours to us to help us do this. But it is challenging. I'm sorry, you had one other part of your question that I don't think I answered.
Less friendly Ninth
Circuit. So when I clerked for the Ninth Circuit, that was 30 years ago. It was known as the most liberal circuit in the country. But during the first Trump administration, as you may know, 10 of the 29 judges were appointed by his administration. And so, for those of you who know how the Ninth Circuit works, a lot of cases, they're decided by 3-judge panels. So literally, it's a luck of the draw, sort of who you get. So we are still obviously litigating plenty of cases in the Ninth Circuit, but there are times when we're litigating cases with jurisdictions in other parts of the country where we'll decide to defer to our colleagues in Boston or in Maryland, Philadelphia, state of Washington. And so, we think a little bit about that. But, by and large, our perspective is the law is a law, and we think these laws should be upheld through our interpretation, not through their interpretation. And our hope is that even with judges that we have in that circuit, that we'll be able to make strong cases.
Hi, thank you so much for being here. A lot of students have already gotten their jobs basically for post-graduation, and for the students who are going to go into private practice, either plaintiffs or defense, at least immediately after graduating, do you have a call to action for what they should be doing, both with their pro bono time and just in general?
Yeah, I have a couple of thoughts. Having gone to Harvard, I know here at Stanford, all of you have probably received many law firms. My guess also is, though, many of you, when you applied to this school, had certain ideas of what you wanted to do as a lawyer that might not be billing 2,500 hours a year at a big law firm. And I would say, if you have decided to go that route in your early years after graduation, think about what you want to get out of that big law experience and execute on that as best you can. So, for example, if you need to pay off your student loans, give yourself a deadline and say, I'm going to pay off my loans in 2 years. And stick to it. Because it's really easy once you're making that money to say, I'm just going to spend some money on some nicer suits and some really nice dinners and buy the better car. Strongly suggest you think about that. But also think about what is the work that just calls you, right? My guess is if your law school is like mine, 2/3, 70% of the incoming first years here at Stanford Law School said you wanted to save the world in some way. You wanted to stand up for civil rights or labor rights or the environment or et cetera. And I want you to think about, what does it mean to stay true to that? And that could mean doing a lot of pro bono work in that space and maybe pivoting to that over time, supporting organizations in this work. We have a huge need for really great litigators on cases, and we would love for any number of you after you graduate with us or offices like us or organizations or individuals who need representation. So make those decisions now. In fact, I'll give one more challenge for you, which is have these thoughts as 3 L's. Write it down on a piece of paper, put it in an envelope, and have a date that you're going to open it up in a year or 2 or 3. And see if you can hold yourself to that. I've given this exercise to folks over the years, and I have gotten a lot of good feedback that when you're billing 2,500 hours a year, it's easy to, and you're in sort of the total institution of these big law firms, it's easy to forget what you're trying to do with your life. You are all too talented, and there's too many bad things happening in the world for you not to do what you had hoped to.
I had a question about, you said that the 3 C's are like the courts, the crowds, and then the courage. My question is, in your opinion, both as a city attorney and as a former state legislator, where do you need like the crowds the most right now?
Honestly, you could use all of it at as many places as we can. I mean, I was surprised after Minneapolis that there weren't more crowds that were protesting Trump. Because I think what we saw in Minnesota were state sanctioned killings. Right? When the federal government initially says, we got this investigation and we are already defending, we've already decided innocence of what's happened. That's unbelievable. And so I do think that just basic protests are important. But I also talk about crowds in the context of organizing in any sector that you are in, because I'm always amazed how consistent sector. Let's say folks who work in technology or AI or more traditional corporate sectors who say, I can't believe what's happening, but I feel so helpless right now. And I think to myself, you're part of the C-suite. You have conversations every day. Leaders, you have much more power than you. And that, frankly, all of you will have those opportunities if you go into big law to engage with corporate decision makers who are part. And so I mean it at 2 levels. I do think folks have to organize. I love the fact that students have helped to drive some of this organizing in this past year. But really people, again, from every background.
Yeah.
Thank you so much for coming here. My name is also David. I was actually as city attorney intern this past summer. I think we saw each other at the Giants game.
I was actually doing some work this summer.
I was really curious. The topic of this talk is about the role of federalism. And one of the things that I'm particularly interested in is the role of state authority and local autonomy. So I'm curious, given your unique experience in the state legislature and then in City Hall and now as the city attorney, if that's given you any particular insight into the ideal balance between the two.
So there are 9,000 ways to answer that. I could probably give an hour lecture on it, but I'll start by saying this. Every level of government has its place for what they do. And there are certainly times when certain topics shift and more. So I'll give, for example, the topic of housing, which had been viewed for the longest time in California law as a purely local issue, right? It's up to local jurisdictions to decide the planning rules, the zoning rules, how cities build housing. And then we had a number of decades where we just didn't build enough housing for the state of California. And we have seen over the past decade a housing crisis that is unprecedented. We have seen record home prices, record rents, record eviction rates, record levels of homelessness. And it's clear we've got to build more housing. In fact, the stat is a few years ago, we had to build something like 3.5 million. And as the chair of the Assembly Housing Committee for a number of years, I initially came to this issue with the perspective of a former local elected of like, yeah, as a city, we should be able to decide how housing happens. Then I go up to the state level and I realize there's a collective action. If we leave it up to every local jurisdiction to decide how they're going to grapple with housing, we're not going to address our housing crisis. And so the issue of housing has been toggling back and forth between local and state jurisdiction. That being said, there are sort of, over the centuries, there are areas of law that have been viewed to be in one sphere or another. I will give an example that's very timely right now, which is public safety. There are criminal laws, but by and large, criminal enforcement, law enforcement happens at the state and local level, right? Cities have police officers, states have criminal laws. As a former prosecutor, I can tell you, criminal laws force prosecutors. And I would suggest there's a really good reason for that, particularly at this moment. You could imagine if all law enforcement were under control, we would be living in 1941. But because in 50 states and thousands of local jurisdictions, our local law enforcement are under the control of cities and states that understand our communities, that have the trust of our communities, that entrust policymakers with how to put in policies to govern how local law enforcement behave. So, for example, we expect and we expect them not to violate the basic civil rights of our constituents. I'm not sure you could say that about ICE, right? And yet, this very issue of this tension between the feds and state and locals on who is going to manage law enforcement is what is at the heart of the sanctuary city debate right now. Trump is all of your police officers, they ought to be mine. I have to be able to send them to capture anyone in the immigrant community that I want to. And we say, well, in sanctuary cities, we believe in building trust with our communities. We believe that if our immigrant communities actually don't think of themselves or don't think of themselves, they need to be witnesses and victims. Victims and witnesses of crime will come forth. Criminals will be arrested. And sanctuary cities happen to have better, if not superior, public safety rates compared to non-sanctuary jurisdictions. So there's not a simple answer to your question, but again, it sort of depends on history, depends on precedent, it depends on the laws on the books and how laws are interpreted, and these things change.
Hey, Attorney, thank you for being with us today. My name is Hai Yan, and I'm an international student, and I'm doing the JSD program here at law school. And my question is about, for the past 2 years, we have known that the Trump administration's action is really fast. And even though the local government can take quick action and sue them in the court, it may still take a long time for the judicial process to really play out. And especially given the limited use of the preliminary injunction, a lot of people are, heavily affected by the Trump administration's actions before the final rulings is out. And if the local governments take actions by themselves, for example, openly oppose the Trump administration's actions, for example, the Minnesota's government doing this kind of thing, resist the ICE actions. This may give a reason to the White House to carry out the Insurrection Act. Do you think, how do we solve the problem of this, the efficiency problem of the judicial process? And do you think the White House will really carry out the Insurrection Act in the future? Thank you.
Simple questions. So, I referred to muzzle velocity at the beginning of my comments, and part of what is diabolical about the concept of muzzle velocity is jamming up the courts. They know that our current judiciary has a certain capacity to be able to absorb all of these cases, and they're moving forward, attacking 10 things a day, knowing that we can only litigate 1 or 2 of these things a day. At this moment, there are about 600 lawsuits that have been brought against the administration. And to your point, these cases take to work their way through the process, in which time the administration is just off doing the next thing. So it provides a real conundrum, one that I know is incredibly frustrating to the bench itself, one that's frustrating to all of us who want the bench to do more, and where we know we're not going to get more judges. Judges are staff. When you have, for example, just the other day, I was meeting with one of the, I think, 17 immigration judges in the Bay Area that have been fired summarily, right? And so now, literally, in the San Francisco Immigration Court, there are just a handful of judges. They literally are overwhelmed. They can't process all the cases they need. Now, that being said, this is why it's also so important for us to be bringing cases, because once we get a judge to focus on something, and if we get a preliminary injunction or TRO, that stays into effect. Certainly, PI stays in effect for a period of time while the case moves through the process. And so it gives us time and protection until cases move. A lot of folks have asked me, well, given where the Supreme Court is, aren't you just horribly worried that you're just starting litigation and all 14-year cases are going to get overturned? I just remind folks what every first-year law student knows, which is it's only a small fraction of all cases that appellate level that actually are granted cert and go up to the Supreme Court, even with the emergency special dockets, the special dockets. So, long-winded way to say it's a concern, but we have been able to do an incredible amount of good with the cases that we had with the injunctions. The last thing I'll say is on the Insurrection Act. Obviously, from my perspective, this president does not have the authority to use the Insurrection Act to come into cities like San Francisco with just on his whim because he doesn't like us. But the way the law is drafted, certainly his attorneys would have a different opinion. I really hope we don't end up litigating this.
Hi, I know we're close to time, but I was curious about what you were discussing about the coalition work you do with other city attorneys and perhaps other organizations, and kind of like what strategic decisions or considerations you think about when deciding like who should maybe bring a claim. I know you talked about strength in numbers, but I guess to provide more context, like prior to law school, I was involved in a civil rights organization where like some of the concern was like, oh, just by bringing this case, like particular plaintiffs may not be so sympathetic to particular courts who are, and I know you talked about the judiciary being independent, but sometimes like it doesn't, there are things that can make, particular plaintiffs kind of less receptive to the court. So was that did that go into the consideration about who you think should bring certain cases and what did that decision making look like?
So obviously we don't have to think as much about the story of individual plaintiffs because we're local jurisdictions, from cities, from counties. But one thing that I haven't mentioned so far is obviously in different jurisdictions and in different circuits, there may be case law that is better for us, right? And so depending on the facts, depending on the laws we're going to rely on, we may choose to litigate an issue in a different part of the country because we know that the First Circuit or the Fourth Circuit just has better law for us. And then directly to your question around who's litigating, if there are individual stories, we're absolutely fine saying, you got this. We'll join in with amicus briefs to support litigation brought by civil rights organizations or not organizations because we think they have the clear standing case. And just also say that when it comes to litigation, part of what we are also trying to do is try to see why the actions of this administration are not just violative of esoteric rules of law and legal principles, but why does it matter to you as a person, and how we tell those stories to change the hearts and minds of Americans through our litigation. That's the component as well. So we'll have those conversations with civil rights. Like if it's more compelling to tell the story of the 5-year-old who got arrested by ICE and litigate it that way, as opposed to have the city of blank or the cities of blank litigate these cases, we're happy to refer. So we have a lot of those strategic conversations.
Everyone, and thank you, David. Unfortunately, I have to rush him to a class right now, so he can't stay and chit chat. We have a lot of great speakers coming today at lunch. Next week, Colorado Attorney General Phil Weiser will be here. So please come. More of these conversations. And thank you, David. That was wonderful.
Thank you. Thanks, everyone.